Welcome to VLGA Connect. My name is Catherine Arndt and I'm the Chief of the VLGA Connect studio. I hope you enjoy today's Connect episode brought to you by the VLGA, the national broadcaster on all things local government.
Hello everyone, it's VLGA Connect Governance Update time, brought to you by Hunt and Hunt Lawyers with the smiling Steve Cooper from the VLGA. Hello Steve.
Hello Chris, I better smile.
Yes,
Hello to you too.
I'm just describing it for the podcast listeners because we have nearly as many people listen as do watch.
Wise people, Chris. The mind boggles at some of your descriptions.
How are you doing?
I'm well, and especially well off the back of a terrific VLGA LGIU panel last evening, moderated by you.
It was a great conversation, wasn't it? We had an English CEO, an Irish CEO, a New Zealand CEO, and Marcus Spiller from Australia, talking about local government reform, and we really heard some interesting stories about what some of these councils and what local government sectors more broadly are dealing with around the world.
Absolutely. Three quite different stories, but with similar themes, Chris. And I think if the night wasn't good enough anyway, when Marcus said, can we get up higher rather than down in the weeds, that made it for me.
What struck me, Steve, was the similarity of issues that are being dealt with. Housing came up so much. Councils really struggling with this problem of where to house people and getting the right support from other levels of government, etc. Of course, the Irish and English CEOs are right in the thick of dealing with the Ukrainian refugee issue at the moment, which is something we're not quite as involved in. So that was a very interesting perspective to hear as well.
Absolutely. And all Chris talked about the need for central government to understand local government and to work well and collaborate with local government to get best outcomes rather than making assumptions and handing down outcomes like a big Monty Python foot.
Yes, indeed. So if you're at a member council of the VLGA or LGIU, you'll be able to have access to the recording of that session in due course. It'll take a few days for that to be up, but there'll be advice from the VLGA when that's available. So look out for it. It's well worth your time. Interesting discussions. So Steve, one of the big stories of the week is the decision in the Badger versus Bayside City Council matter at the Supreme Court. You'll recall this was about political signage and the Zoe Daniel campaign with a pending federal election that we think is going to happen around May, but that's one of the points, isn't it? We're not exactly sure. And we're pleased to have with us from Hunt and Hunt Lawyers, our terrific sponsors, Andrew Gunter, to explain what's happened this week. Andrew, welcome to the program.
Thank you, Chris and Steve. Great to be here.
Good to have you with us. Can you firstly just briefly set the scene for us, just remind people why this matter has ended up in the Supreme Court?
Well, Chris, it was a case where an independent candidate in a federal seat that includes the Bayside City Council area had sought some guidance from the council in question to determine if signs could be put up in people's front gardens, for example, private property, to promote or advertise the candidate they supported. And the council had initially said, well, that's not going to require a planning permit, so that's all right. But then subsequently, the council took a position that the strict reading of the relevant clause of the Bayside planning scheme, it's a planning scheme control that's common across Victorian planning schemes, meant that a candidate or supporter of a candidate couldn't put up a sign of that kind for a period of longer than 3 months, including the event of the election, so that it was necessary on that interpretation by the council for the writs to be issued for the federal election, which may be in May or theoretically as late as 3rd of September, and that without that particular exemption available, each person wishing to put a sign in their front garden would need to get a planning permit. And there was an unusual situation because very few other councils had ever raised this, and Bayside was the one who'd taken it this far. Mm. The campaign director for the independent candidate then went off to apply to the Supreme Court for a declaration and an injunction in relation to Bayside Council's actions. And essentially that decision was handed down on Wednesday, saying that the planning scheme needed to be interpreted differently from the way the council had determined. And essentially there had been several options put forward as alternatives by the plaintiff as to how that clause of the planning scheme should be read. But essentially the broad position is that it is possible for a person with a front garden wanting to promote a political candidate to put up a sign, a call flute sign on a fence, for example, for a period of 3 months, whether the election is called or not in that period of time, or if the election is called and then is held, and a period of 14 days after the election expires, before the 3 months expires, then the sign would need to come down at that point. And that's a fairly plain reading of the planning scheme, and a reading that most councils and most lawyers had already put onto that provision of the scheme.
So, Andrew, is it fair to say that, and I know there were multiple options put by both parties for consideration by the court, but the council, is it fair to say the council was substantially relying on the fact that the election hadn't been called because the writs hadn't been issued and therefore there was no event?
Yes, that's right. The provision of the scheme that regulates signs of this kind, and it's the same provision that regulates primary school fete signs and the like, promotions of local charity fundraising events and so forth, hangs its timing in many respects onto an event. And the council took the view that an event had to have a specific calculable date. For example, with Victoria's fixed term parliamentary elections, we know that the next election is going to be a date in late November 2022. We know which Saturday it's going to be, but that's not the case for federal elections. So the council argued, well, you don't know the date of the federal election, so it can't be an event to allow this exemption for political signage until the writs are issued by the Governor-General on the Prime Minister's advice. So that could be as late, according to the Parliamentary Library, as the 3rd of September if the Senate and the House elections are separated. Pretty unusual, quite unlikely, but constitutionally possible. And so therefore the council was of the view that you wait for the writs, then you can put your signs up. And the court said no. Its opening line of the decision, His Honour's opening line of the decision was, it is notorious that there will be a federal election in 2022. And that set the tone, I think, for his thinking. Yeah. And for the conclusion that, yes, it is an event, even though a date for the event has not yet been set. It's only the date that's unknown, not the event that's unknown. Therefore, the signage was, in his view, capable of being put up, but only in accordance with the provisions of that clause, 3 months, or if earlier than that, you've got a 14-day period following an election, it might be held in 2 months, then at 2 months and 14 days, you have to take your sign down, or you're in breach of the scheme, or you need a permit.
Andrew, I'd like to circle back to that shortly, but the judge also made a distinction between development and use. Why is that important?
Well, development is a distinct concept from use in planning law that basically treats the event of constructing a building or a structure, a hoarding for a sign, a billboard, or works, civil works and the like, an event to bring a new state of physical facilities into existence. That is development. Use is, in broad terms, the purpose to which the development is put after it's constructed. And comparatively recent changes to that clause in Victorian planning schemes made abundantly clear that signs don't require planning permits for use. That's an exemption in the general provisions of Victorian planning schemes, but that signs do need either planning permits for development of the putting up of the sign, the structure of the sign, and that once that's been done, either by having a planning permit for it, or fitting into specific exemptions, like the 3 months publicity for an election candidate, then the development is complete, and then the use doesn't need to be regulated by means of a planning permit. So it was important to take the earlier decisions, the pre-2018 decisions, where that distinction hadn't been so clear, and clarify how it applied in this unusual circumstance that's come up soon after the scheme provisions were amended.
So it's a useful case. Now,
it is.
Speaking of useful,
signage generally.
Yeah, speaking of useful, a lot of council officers and even councillors would have been interested to see whether this case shone any further light on interpretations regarding political expression and how that might sit alongside planning law. Did this case help at all?
Officially, not much. Informally, somewhat. And the reason I say that is because the judge made a decision in relation to the interpretation of the planning scheme that resolved the dispute between the parties, the candidate's campaign director and the council. And because that was capable of being resolved just as a matter of planning law and interpreting the controls, and then issuing the relevant declaration as to the state of the law applied to these facts, it wasn't necessary for the court to go on and make decisive statements of a rationale for a decision about the political, the implied political communication question. However, the judge did make sure that the plaintiff had informed the Commonwealth and the state attorneys general about the proceeding. And the reason for that is provisions in Commonwealth judicial legislation that require any state court that's deciding something that may have federal constitutional implications to invite the attorneys general of the Commonwealth and the states to join the proceeding if they want to make submissions about it. Time was permitted for that. It was very compressed, of course, because the proceeding was only launched in February, but all but one of the attorneys general had come back and said, we don't seek to intervene in this proceeding.
Yep,
and
off you go.
I suspect the reason for that was that, having had a look at the facts in front of Justice John Dixon in Victoria, they said, oh, look, this looks like it's capable of being decided as a matter of planning law and won't necessarily need to dip its toe into the broader issues of implied political communication. So he did, however, make some more informal comments about those questions, but wasn't going to nail his colours to the mast.
Andrew, just the last one, and people will be alert to the fact that occasionally we have stakeholders who are looking for the Larry loophole in a piece of legislation. Now, what if, hypothetically, the election wasn't going to be held until September and a sign was elected tomorrow, or say today, the 25th of March, it would need to be taken down on the 25th of June by your calculation.
That's correct, and the strict reading of the decision suggests that's the case.
Did the judge say anything about the capacity to re-erect another sign after that?
Yes, he did, and again, because that wasn't an actual event that was disputed before the court, his comments on that have to be treated as advisory comments, sometimes referred to as obiter dicta, which is basically commentary that may assist in providing context or guidance, but has no binding function. He did say that the controls limited owners of a particular parcel of land, a front garden, for example, to putting up just the one sign to meet this exemption, but it wasn't one sign for any particular event. That is to say, if you put up a sign for 3 months and the event doesn't happen for another 6 months, you're not limited to having only one sign there. What you're limited to is only one sign at a time. So it's on the informal commentary that he's made, it would be fair to say that putting a sign in the front garden for a candidate from the 25th of March to the 25th of June is fine. My personal view is that out of an abundance of caution, you should take it down. And then on the following day, there is no problem because there's no currently existing sign on the site on the 26th of June. It's possible to put up another sign, whether it's a slightly different version of the same campaign material or in fact the exact same sign. The implication from the decision is that will be fine. The rule being limited to the 3 months and one sign at a time, and then of course no more than 14 days after the event, if the election happened to be 14th of May, which is one of the dates being talked about, then the 28th of May would be the day you'd have to take it down.
Andrew, perhaps one last question from me. I do recall in the hearing the judge suggested that the ruling would likely have implications statewide.
Yes.
Is this something that planning directors, regardless of where they are in the state, should be taking heed of? Does it have that broader implication for local government?
Yes, it does. And one of the great benefits of the introduction of the new format planning schemes is the degree of commonality between planning schemes across the state. Obviously, there are numerous variations in types of zones that planning schemes across the state have, but there are a core of possibly 60 to 70% of the clauses that are quite common across the entire state. And clause 52.05, the one regarding signs, and the exception clause 5205-10 are common, and they are quite useful for signage generally. For example, fundraising signs, primary school fete signs. The same types of the same types of interpretation are going to apply broadly for all of those situations. Signage for events, particularly non-commercial events, and essentially this exemption clause relates to non-commercial events. So, and there are so many of those throughout the communities across Victoria that planning directors would want to have the benefit of the clarity that this decision provides.
Andrew, thank you so much for explaining that. Steve, any more questions? Or terrific, you're done.
Andrew's exhausted me. Thanks, Chris. Indeed. Thank you, Andrew.
You're most welcome, gentlemen, and look forward to future episodes.
Terrific. Thanks for being part of the governance update, and we'll talk again. Well, Steve, that's been very enlightening. One thing we didn't get into with Andrew was the issue of costs, because of course the judge has awarded costs against the council. We don't know how much that would be. We'd just be guessing, wouldn't we?
I think, yeah, we would be speculating. Never a cheap outing to the Supreme Court, Chris, and it's always one of those things that the council may object to the amount of cost claimed, which might see them back in court again.
5 figures, 6 figures, what's your gut feel?
Yeah, I don't know. Possibly 5. I suspect there'll be a clamour for the costs to get a public airing, though, Chris, and people will be interested in that.
Absolutely. All right, so we'll keep an eye on that, and really appreciate Andrew Gunter spending the time to explain that to us. And as he said there, implications for statewide, and a bit of reading perhaps, or a bit of understanding for planning directors that'd be well using their time on.
They would be. Can I just make one point on the question of the cost, Chris, is
Sure.
that cases such as this are useful, and without parties taking matters to court and having them tested in court, we don't get the benefit of the decisions to inform future actions by public authorities. So, on the one hand, the costs will seem expensive, but on the other hand, our system really relies on matters like this.
Yeah, good point. Okay. Now we've got lots of other news to get through, so we'll try and whip through this, because I know people look forward to us trying to keep our finger on the pulse for their benefit. We've had some councillor developments this week with, let's do this one firstly. The Deputy Mayor of Mildura Rural City Council, Cindy Power, has resigned this week as a councillor and left the council. This was interesting, Steve. She made a statement on her Facebook page saying she was making the decision for her mental health, that no position is worth your mental health, she said. And while some may say this is letting the bullies win, she's choosing to do this for her personal well-being, which is a great shame. And that's going to trigger a countback at Mildura.
Pretty robust politics in Mildura is a fairly kind way of putting it. Chris, and I've met Cindy Power, who is the time I met her, a pretty decent human being, and it's a sad thing if people in local government feel that that sort of toxicity is more than they can bear. We can't go into any more detail other than what's been published in the media, and I presume we'll pop the ABC story on the show notes. But I was interested that Bill Forward at our Fast Track event last week, former Liberal politician, made the point for councils that one of the tactics, I suppose, for managing culture is to be really alert to how the community engages, and to not, reward bullying public behaviour, that there is a level of civility that should take place even in the most contested issues.
A good point too. My sense is, from reading some of the material, even went on ABC Mildura to talk about this during the week, that it's largely in the community, not within the council organisation, the source of the issue here. But that's just my sense. It could be a bit of both, and that's a really difficult area to tackle.
It is, and it's challenging, and look, we don't know what the issues are. So I am speaking generally, not about Mildura, but it would be tempting, for a councillor, being quite human, if they were on the side of the rancorous community, to allow that to continue. But maybe, we should be calling some of that out at times, and thinking through, what that civil debate looks like.
Quite human, you say, councillors?
Very human. We're all human. Subject to human frailty.
Indeed. Moving on, the Mayor of Warrnambool, Richard Ziegler, has stepped down this week. Now, he's going to stay on as a councillor, but he said due to health and family commitments, he can no longer devote the time to the mayoral role. And here's an example where the Deputy Mayor, Debbie Arnott, is stepping up as acting mayor for the time being, and the council has said it will hold a meeting soon to elect a mayor to complete the current term through to around November. So we wish Councillor Ziegler all the best.
We do.
A couple of election results. A countback at Moreland. Second attempt was successful, and Monica Hart was elected by the computer count from the 11 remaining candidates. I understand it's been reported Monica is the 30th openly LGBTIQA plus councillor in Victoria. That's an interesting milestone.
It is. So we are approaching half the councils in Victoria where presuming if you went, one per councillor, where, a publicly declared LGBTIQA plus councillor is represented on the council. There may be more who have chosen to not declare, and that is a matter for them. But I think a celebratory milestone there, Chris.
Absolutely. Couldn't agree more. And for Maroondah Council, the Wonga Ward by-election result was confirmed this week as well. Linda Hancock is the successful councillor. So great to see some female councillors getting up at countbacks and by-elections, Steve, because it was very much trending the other way before this week.
I think we were lamenting that a few weeks ago, Chris, so how quickly things turn around.
Indeed. Okay, let's look at some other news stories of interest and just touch on these. I know this one caught your eye in Hornsby in New South Wales. The council there, or the mayor's Philip Ruddock, by the way, has threatened, and that's important to know the political alignment here, has threatened to not have rubbish bins collected if they've got the Throw Scott Morrison Out stickers on them.
I think that you need to work on the presumption, Chris, that could be purely coincidental.
Could be.
That the critical issue that the council is saying is that the stickers are obscuring the council logo, and how can the driver of the refuse truck possibly know which are the bins that they should be collecting?
Okay. Yeah, okay. I could see how you might run that argument. Am I just being too cynical here, am I?
Well, Chris, the suggestion has been made that people in the past have put stickers on their bins supporting particular football teams and so on, and the council hasn't been bothered about that. And it would be a concern were the council to be acting because of the content of the sticker rather than the public interest associated with the display of the council logo.
So let's be serious now for a minute. So rubbish bins are the property of the council?
They are.
Yeah. So you've got visual pollution issues, you've got the way an asset is treated. There's a whole range of issues here.
There's a really tricky one. I kind of think that, councils, let's go to the clearest example. If someone puts a political poster on a fence at a council reserve that belongs to the council, that's really simple. We just take it down. Yeah. I think they've affixed it to council property. It gets more complicated if someone puts a poster on a light pole that might belong to a poles and wires company. It would be interesting to know what the attitude of individual councillors is to that, particularly, and it's not planning law, it's a local law, particularly in that period leading up to the election. And I think that's a really good advertisement for councils to have enforcement guidelines that contemplate these various situations. So we're not waiting for a complaint and deciding what to do, that we've got a guideline in place. I think most of us in local government have been in that blissful situation where a resident brings in a copy of the local law, points at it and says, your local law says this and they should be fine, do your job. And it's not that simple. So we've got local laws that dictate a whole lot of things about what to do when your bin gets put out. Where you should put it, it should be facing the street. The lid should be completely closed so the birds don't spread waste everywhere, and you should be able to see the logo.
Yeah. Now, what is it? A metre distance between bins, something like that?
Yeah, and I think I breach that one occasionally. You just wheel your bin up. So now there's another issue too, Chris, that someone put to me years ago, that when we progress a matter to court, it represents a failure in every element of our system before that, because we should have been able to persuade people to behave appropriately. We should have put the information out to start with. When we're aware of a breach, we should have intervened and communicated. Like, there's a really strong argument to not be heavy-handed early days where there is a breach of a local law. And I would also question that if a refuse truck driver drives into a street and there's basically one bin per house, well, why wouldn't you just pick up the bins? Because there is a public interest in the bins being picked up. And I don't see a great public interest in the bins not being picked up. Now, engineers and so on will tell me that, you need to know it's the right bin, and there's a whole lot of issues about, making sure it's our bin. But, I just think that's a real issue. So we're back to sort of that question in this particular case. Are we acting because we're really concerned about the sign, or are we acting because someone's beating up on the council because the signage happens to be political?
Yeah. Okay, we'll leave that for others to decide. I do like that analogy of, if it goes, probably the wrong use of the word analogy, but if it gets to court, there's been a failure of the system. That's probably true in most occasions. Sometimes it's just because someone's being bloody minded, though.
Oh, I think so. Oh, absolutely. No, and I don't say that it's never going to be happening. There are times where we need to take matters to court, they should be, and it's quite reasonable. Councils shouldn't be not proceeding with matters on a whim, but it should be based on a sound assessment of the merits. But equally, sometimes it's a bit difficult when some of the same people who are looking for councils to show discretion in their exercise of local laws might, in another circumstance, be, seeking enforcement to the fullest extent of the law.
Steve, we're going to have to wrap it up. I've got more stories, but I think we're out of time. We're probably wearing out our welcome. I do want to just touch on this one, which caught my eye. I thought this was interesting. We talked last week about differences between states in terms of local government legislation, etc. In New South Wales, this coming week, I noticed the Dubbo Council is going to consider a new senior staff structure that the CEO is bringing forward formally to the council. And in reading that more closely, because I thought, why would the council need to be deciding on levels below the CEO? Apparently, it's in the Local Government Act in New South Wales that within 12 months of the formation of a new council, that the council and the CEO review and determine a structure of the organisation. That just fascinates me, and I'll be interested to see the level of discussion that happens around that matter when it comes to Dubbo this week.
Like you, Chris, I'm torn on that. My optimistic side would say, wouldn't it be good if the CEO and the council, going through the briefing process, can have a really sensible conversation about why the structure is the way it is, and that would add to the shared understanding of what we're trying to achieve and how we're going to get there.
Yeah, I'm reminded of the workplace plan requirements on CEOs in Victoria. Most did not put that workforce plan through a formal council process because there's no requirement to do so. It's clearly regarded as the purview of the CEO. So there you go, another subtle difference between this state and the one immediately to our north.
We'll file that under watch this space, Chris. Good to talk.
We learn something every week. All right, thank you, Steve. We'll wrap it up. A few more stories of interest. You'll hear about them on the Local Government News Roundup podcast, which comes to you on Sundays and Wednesdays. Don't forget to subscribe to that on your podcast app. Don't forget to subscribe to VLGA Connect as well on YouTube and your podcast app. More episodes coming at you next week, some of our fast track highlights. Steve, fast track out of the way, global panel out of the way. What's next for the VLGA?
Well, the one I do know about is we've got a councillor development session live in the offices of Hunt and Hunt Lawyers, coincidentally, on the 29th of April at around lunchtime, and we're going to be talking about land use planning for councillors with Tony Rounick.
Brilliant. Okay, there's a heads up for you. Get in and reserve your spot for that. Steve, have a great week. Talk to you soon.
Thanks, Chris. You too.
Steve Cooper, Chief of Staff of the VLGA, and our thanks to Hunt and Hunt Lawyers, the sponsors of the Governance Update. Thanks for watching and listening. We'll see you again soon. Bye for now.